Welcome back to the workshop series. Today is the third discussion of generative AI, software that can mimic human creativity from a legal perspective. In past videos, we've discussed the general concepts behind generative AI and whether the models used in it are likely to be declared illegal. If you didn't watch the prior two videos, I suggest you do, because this one will build on them. As I've said before, this is a rapidly evolving area of law, and my observations here may well become invalid as new law emerges. But you'd probably rather not be the test case that helps that new law emerge, right? That's why we're going over some general legal information on the topic here. What are people using generative AI to do? It's too early to have a lot of good data on exactly how much it's being used for various things. We're still in the hype phase of this technology, but we can say a few things. Individual users are busy using generative AI to make artwork for book covers or clip art for websites. People are using it to try to get a job as artists or whatever, just by prompting their AI. Media companies are using generative AI to spit out blogs, articles, and otherwise to generate content online. Companies are sprouting up offering apps for legal advice, medical advice, customer service, tutoring, document summary, and even virtual romantic partners powered by large language models. But beyond this, I suspect we're going to see the use of generative AI sneaking up on businesses indirectly. Think about how many times a day your employees might be using a search engine on the World Wide Web to find or verify something, or how many times they need to put together a written summary of something, or catch up on emails after vacation. I have compared generative AI to a calculator for writing or art as a new kind of software that will just become more and more common as a supplement to white-collar work, and I think that's true. If you run an office, I would bet some of your staff have been tinkering with this software already. Whether you know you're about to start experimenting or you need to play catch-up with your employees, there are legal perils involved in the use of generative AI. As the user, you are the one actually producing a new creative work and trying to profit from it, with all the liabilities that come with it. If you build a product with AI, you're the one making representations to your customers. If the AI is in your workflow, you're the one who has to deal with the quality of its work product. So that's going to be the focus today. Since I'm a Colorado attorney, my focus is going to be on Colorado law. And in general, I would propose there are 5 big no-nos when it comes to generative AI. Don't be too eager to exploit the hype. Don't use AI to do bad things. Don't assume your work product is protected or safe. Don't allow your AI to operate unsupervised. And don't give away your future. Hopefully, when we're done, you'll have a keener grasp of what risks exist and perhaps even come to appreciate why the current providers of generative AI do so much work to control and censor their operation. And maybe you'll get an appreciation for how much work it takes them to get the results as good as they do. First, don't be too eager to exploit the hype. Even though we have no federal regulations for generative AI specifically just yet, that has not stopped the Federal Trade Commission bloggers from working overtime publishing articles on their website, warning people not to misuse the technology. The FTC warns that if companies overpromise or mislead people about the use of AI in their products or what the AI can actually do, they can be held liable under the Federal Trade Commission Act. The federal act is fairly broad and prohibits unfair or deceptive trade practices where it applies. In the case of AI, unfair uses include uses that cause, or are likely to cause, harm to the consumer, cannot reasonably be avoided, and are not outweighed by a benefit. In the FTC's view, algorithms that discriminate unlawfully are a problem, as are luring people to doing business with you or making harmful choices. So, if you use generative AI to analyze a user's activity or statements, and then employ it to produce custom advertisements designed to entice the customer to make a bad decision, that may be a problem. Deceptive, meanwhile, means something that is likely to mislead the customer. If you claim your product is powered by AI, make sure it actually is. That's a little tricky because in some sense the term AI goes back to the very first computers and has been applied to a broad range of computer activity. As the term is used today, it usually refers to machine learning and maybe even to generative AI specifically now. So if your product is using good old-fashioned procedural computer code to make decisions, be careful about advertising the use of AI. Colorado has a similar law to the federal one, the Deceptive Trade Practices Act. This gets a little more specific than the federal law, and it prohibits, among other things, false representations about goods or services. Again, a business using AI should make sure it doesn't make false representations about what technology is being used or what it is capable of. Which brings me to the second no-no. Don't use generative AI to do bad things. It turns out that practicing law without a license is a bad thing. So is practicing medicine, certified public accounting, public adjusting, or any number of other regulated professions. The model may have been trained on work product from regulated professions, and so it might be able to provide access to this information to laypeople. But the minute that you go around treating the AI as if it's a replacement for a licensed professional, you could be in trouble. A large language model may be able to pass the bar exam, but even then it doesn't have a license to practice law. There is already one company testing the limits here. This company was quick to advertise the use of generative AI as a kind of robo-lawyer to help laypeople write complaints or even advise them in court using an earpiece. Last I heard, this company is being sued, possibly being moved into arbitration, and has received threats from regulators. It's also going to be a problem if people rely on your business generative AI for something like medical advice, for example. For now, anyway, the only proper use of AI in regulated professions is probably in the hands of those who are licensed to use it. Another bad thing you should not do with generative AI is garden variety fraud. Even if it's not infringement for a model to be trained on someone else's art, it's still not okay for you as the user to create the new work and fraudulently claim it was made by that artist. Nor is it all right to replicate someone's voice using AI and then steal their identity or try to trick their friends and family. It turns out that things that might otherwise be legal can quickly become illegal if you add some lying into the mix, so don't do that. The next rule is, don't assume your AI work product is protected or safe. This one is a doozy, and it has to do with how these models currently work. To begin with, most of the truly powerful models require massive computer infrastructure to run on. The models themselves may only be tens of gigabytes, but the mathematical operations to run them get wacky huge really fast. So they tend to run on servers maintained by large companies like Google, OpenAI, or Microsoft. Even third-party providers of access to models might be, in turn, just using these other resources. This means that confidentiality is a problem. Businesses deal with confidential information all the time, from trade secrets and intellectual property, to customer private data like credit card numbers, to legally protected information like medical or student information. If this information is provided to a large language model, is it protected? Possibly not. The terms and conditions between you and the operator of the model may disclose that you're giving them a license to use your work product in some way. The terms and conditions may require you to allow the model operators to ingest your input into the model for training purposes. This could cause the model to learn privileged or confidential details about your business that could be regurgitated later. Not great. Thus, before using any model, a business should scrutinize the terms and conditions. It would also be a good idea to ask about the technical details of the model. Is it being shared with a public-facing model, or is it a private instantiation? Will one customer's data be ingested and possibly spit out by someone else? And since some of the companies offering AI services might be new, Their track record on data privacy and breaches is important. OpenAI has already had a few high-profile data leaks early in its development. So, if you're thinking about hiring Joe Bob's bargain basement secretary replacement service powered by AI, maybe take a close look at how reliable they're going to be with your data. Another option to preserve confidentiality is run a model locally. There are already models out there that you can download and run. They don't require more than a high-end gamer's graphics card with a lot of VRAM. None of these models are powerful enough to compete with the professional ones yet, but as people continue to tinker with their performance, that may well change. Your IT department might be able to help set up a local system that would suit your needs if your business wants to use a model for something very basic. Of course, you'd want to make sure the models you download are available to use for commercial purposes and free of viruses and malware, none of which you should take for granted. In addition to not being protected by confidentiality, the work product of generative AI may not be protected by intellectual property law. The United States Copyright Office has been quick to remind people that it will not issue copyrights for works created by a non-human. One famous case making this point was Naruto v. Slater. In that case, a photographer dropped their camera in a monkey's enclosure. The monkey took a picture of itself. When the camera's owner retrieved it and made use of the picture, animal rights advocates filed a lawsuit on behalf of the monkey, claiming that the monkey, not the photographer, had a copyright in the picture. The court disagreed and explained that only human creativity can result in copyrights. Animals are not eligible. Neither are computers. In 2018, the Copyright Office refused to grant a copyright to an image that was produced by software called a creativity machine by its author. And more recently, it refused to give a copyright to a comic book where the images were generated by AI. In both cases, the Copyright Office contends that if the traditionally creative elements of the work are done by something other than a human, there is no copyright. There is guidance available from the office online that goes into more detail than this, but essentially, you need to show a human provided creative control. Just coming up with the prompt is not sufficient in the eyes of the Copyright Office. It's possible litigation will result in a more nuanced line drawing here, but for now, I would assume that the output of your generative AI is not itself copyrightable. Does that mean we're in a new age of freedom from copyright and free all of digital assets? No. Even if the output from generative AI is not immediately copyrightable, it can probably be made so by having an artist go in after the fact and tinker with the design. Repainting, using the AI output as a guide or a reference, these things may well end up creating a work that is protected. Another way in which generative AI is unsafe has to do with its unpredictability. Because the model cannot be predicted in advance and the output is out of the user's control, it is entirely possible for a model to produce an output work that is infringing on prior existing work, even if the user is completely oblivious. This raises a very interesting question. Can you be accidentally liable for copyright infringement? This is hard to answer. On the one hand, in order for there to be infringement, the creator of the new work must have been at least exposed to the prior work. There must actually be some copying going on. If two people create something similar completely independently, it's likely not infringement. If your child's stick figure family drawing is the same as another stick figure family drawing by a child in a different city, and they've never seen each other, no copyright's being violated. On the other hand, courts do refer to infringement as strict liability because the copying does not have to be intentionally violating a copyright. Subconscious copying is enough. So, as long as the new user had access to the original work, the new user might be liable for infringement, even if it was inadvertent. So, in the case of generative AI, will it be enough for a creator to show that the model used to make the new work was trained on the old work? And if so, does this mean that if a model produces an image that is potentially infringing of a prior work, the plaintiff needs to go subpoena the tech company running the model to find out what it was trained on to prove liability? These questions may not have clear answers in the existing law. It seems prudent to check what your model is spitting out for potential infringement before deploying it. Before you publish your children's book with images you spun up in Midjourney, maybe run them through an image-to-prompt model and see if that tells you they look like an existing artist's work, or maybe run a Google reverse image search. Or for big deal uses, perhaps hire lawyers to run copyright searches before you use it. I don't know if this level of due diligence will actually help in court if you get sued, frankly. But it might alert your company to the possibility of a problem early enough to dodge it. This unpredictable behavior leads me to the next no-no. Don't allow your AI product to operate unsupervised. Remember, generative AI is not so much designed as it is evolved. The models of relationships between text input and creative output were not carefully calibrated like a watchmaker makes a watch. They were the result of finding a multidimensional equation that best matched the original data. Then, possibly doing more training or tweaks to nudge the model's relationships in a different direction. Since no one designed the model, no one really understands how it works. Heck, there are people out there who are using the techniques developed in human psychology as tools to try and probe what the AI might be doing. Not only that, but we don't really even understand how well the training process works overall. There are reasons to believe at a fundamental level it might never be possible to predict these kind of programs. If you're into a deep dive, I suggest checking out the videos from Robert Miles on AI safety. He does a good job of summarizing the research without getting too deep into this curious scuffle between the AI ethics and alignment folks. Anyway, the point for a business owner is that an AI model is unpredictable. It does not produce the same output every time, even on the same input. You shouldn't anthropomorphize the technology, but at least for reliability purposes, think of generative AI as an unpaid college intern with access to the internet. She's got endless free time and access to all human knowledge, but she's also untrained, has no wisdom in your business field, and has no particular loyalty to keep your business safe. If you wouldn't trust the unpaid intern to do the job unsupervised, don't trust a large language model to do so either. What is more, large language models in particular are vulnerable to unwanted behavior arising from interactions with the users. The model uses human language as its input and its output, as its data and its instructions. It's almost like it uses human language as its computer code. So people can carry out attacks called prompt injections, even inadvertently, that cause unwanted behavior. If you're interested, it gets this name from hacking, whereby the hacker tries to get a computer to accept malicious instructions using a pipeline that was designed for data, like usernames or information. Avoiding this usually means taking care and sanitizing your input to screen out characters or tricks that might result in the incoming information being read as instructions. But in the case of a large language model, the data is the instruction. And what's worse, the output from one question influences the next. So problems can spiral out of control once the model is fixed on a bad idea or bad behavior. So if you deploy your generative AI in a public-facing way, it could get you in trouble beyond copyright infringement. For example, if you embed a large language model-powered chatbot as a help desk on your webpage, that model might end up doing bad things. Like we've mentioned before, it might provide false information to the customer that may get you in trouble with the Deceptive Trade Practices Act. It might practice public adjusting without a license. But that's the tip of the iceberg. If it's asked about real-life people or companies, it might provide false and damaging information about them. In Colorado, defamation only occurs when one publishes false and defamatory information about someone else. There are kind of accusations having to do with sexual diseases, crimes, or one's livelihood that are so bad they're called defamation per se, and the victim doesn't even have to prove damages. If your generative AI ends up accusing someone of being a sex offender or produces a passable photo that seems to show someone committing a crime, you could imagine how that might make some people upset. Another problem with unsupervised models, like an untrained intern, is the potential for discriminatory actions. These models are not, for now, trained on the real world. They're not limited to just scientific measurements about things. Instead, they're trained on the prior output of human beings. That means that our collective assumptions, stereotypes, and values may be embedded in the model. It means that if the model is making decisions, predictions, or recommendations, it might end up having a discriminatory impact. There are some examples of this. According to news stories, a few years back, Amazon realized its resume reviewing AI was producing a discriminatory impact based on gender. This was not due to some underlying scientific reason the AI had uncovered why men are better at online shopping, but because the data set used to train the model was already biased towards men. Another example cited for disparate impact includes the Correctional Offender Management Profiling for Alternative Sanctions, COMPASS system, used by some of the United States to predict recidivism. At least one study found that COMPASS wrongly predicted recidivism among Black individuals at almost twice the rate it wrongly predicted white individuals. Note that this study was not talking about how much recidivism the model predicted overall. It was specific to the number of times the model objectively got it wrong because the person did not actually reoffend. As you can imagine, studies about bias in AI are not without critics, and there are counter-studies that push back on this. From your vantage point as a business, however, you don't want to be going anywhere near a debate about disparate impact if you can help it. Discrimination on the basis of race, gender, or other protected class can get you sued under Colorado or federal law in a variety of circumstances, such as employment or insurance decisions. And generative AI that interacts with people may offer an interesting angle on these issues of AI bias that others don't. The COMPASS model, for example, is never going to say racist things. It's not going to crack a joke about women. But a large language model, properly prompt injected? Maybe. So you might be in a situation where not only might the model have a discriminatory impact, it might say something that a plaintiff's attorney can use as good evidence of discriminatory intent, whatever that means for an AI. Very strange. And Colorado is actually at the bleeding edge of regulating discriminatory AI. In 2021, the state adopted Senate Bill 21-169, which restricts insurance companies' use of customer data. It specifically prohibits carriers from using algorithms that unfairly discriminate. And the regulations over this law require regular review of the carrier's algorithms to detect whether they're biased or not. The same year, Colorado passed the Privacy Act, which requires companies that handle a lot of customer data, particularly if they sell that data, to comply with requests to avoid data mining and other AI-related actions, possibly even injection into a model. Senator Michael Bennet, meanwhile, has proposed federal legislation governing the use of AI by the federal government. So, if you are doing business in Colorado, be aware that our state government is more likely to be tackling these issues sooner than most. Now, you might be wondering if you can be liable for what generative AI says or does on your behalf, even if you didn't intend it. Probably yes. You may have heard about some federal laws that have safe harbors for people providing information on the internet. This has come up a lot in debates about false information on social media and the government's inability to hold sites hosting that data accountable. But no, these probably don't help you if you've deployed a misbehaving AI. Section 203 of the Communications Decency Act states that, quote, "No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider." In other words, if you have an online forum, you're not necessarily responsible for bad things that people write or say on that forum. But this safe harbor does not protect your company from things your company actually says or does. So, when your generative AI is producing text or images, who is providing that content? There isn't clear guidance on this yet, but I'd be concerned that if your company is running the AI, your company is probably the publisher and speaker. Section 203 does allow websites to use neutral tools to access information from third parties without becoming liable, but generative AI doesn't really store third-party information. The models map text prompts to elements that humans describe in the type of creative work being generated. For the same reasons that I discussed in prior videos about generative AI likely not just being a compression algorithm, I don't think it's likely you can argue it's a neutral tool either. Finally, the more interactive and human-like large language models get, the more I'm concerned about some problems arising that formerly were only an issue with live human employees. Can your generative AI agree to enter into contracts as an agent of your company? Can it agree to modify your terms and conditions? Can they provide third parties arguments for reasonable reliance or equitable estoppel by making representations about your business? All of these come up because the AI is able to mimic human behavior in a way that has never before been possible. The takeaway here is that if you're going to use generative AI in any capacity in your business, supervise it. If you want intellectual property protection in your creative work, have someone skilled in that art take the initial output and work it up to make sure it'll pass muster with the Copyright Office. If you need legal advice, have the AI help your lawyer be more efficient rather than relying on Bing to represent you in court. If you want to make a customer service bot, make sure there's a human watching the input and output who can intervene or approve messages. From where I sit, providers of generative AI are making great strides in improving the reliability and safety of their technology in day-to-day business use. But they are all fundamentally trying to restrain an unpredictable animal. Supervision by humans with wisdom and context is key. Which brings me to my final no-no. Don't trade away your future. Now, you shouldn't fall for the hype too much and sign up with a generative AI provider who's promising you the moon. But that's not what I mean here. What I mean is more subtle. Generative AI is not currently better than expert-level humans at various tasks. Where it is able to do high-quality work, it's often prompted by people who are experts. Out of the box, asked a simple question, the software tends to produce generic and sometimes downright vapid results. Art programs barf out pictures of young ladies that look like makeup ads in a magazine. Large language models provide canned-sounding responses in a predictable format of introduction, topic 1, topic 2, conclusion about how everyone should sing Kumbaya. That's not better than hiring a skilled human. But here's the thing. It might be better than hiring an unskilled human. A large language model writes better than a good number of actual living humans. If you're hiring someone new, knowing you're going to have to train or prompt them to get a result, and then tell them to redo it and supervise them anyway, there is a temptation to just use the generative AI instead. It's cheaper, after all. I think this is subtly dangerous as a way to mortgage away your company's future. That unreliable, unskilled intern we talked about earlier won't stay unskilled forever. If they stick around, they'll develop and learn skills. They'll become an expert eventually. By hiring them, instead of relying on generative AI, you're building something that can outlast you. ChatGPT is not going to be buying your business in a succession plan. It is not going to help mentor the next generation. Similarly, if members of your organization rely on generative AI too much, they may not be developing skills on their own. I observe people will often follow the path of least resistance. If the AI spits out lesson plans or email responses that are good enough, what incentive does the user have to keep working on developing the skills to do it themselves? And it gets even more basic than that. As a lawyer, I often deal with complicated commercial litigation. Lots of documents, lots of witnesses. Now, getting ready for a hearing or a deposition or whatever takes a ton of time. A lot of that is spent poring over the records and summarizing them. I expect that sooner or later, generative AI will be able to automate that process. Some clients will benefit from the cost savings. But I, as a human being, will be less capable at a hearing or deposition or whatever because I didn't do the work myself. I didn't train my own biological model on the data set. I won't have information at my fingertips. It's like studying for a test in school. The hard work happens while you're studying. The test? That's just performance art. Now, it's possible my concerns are going to turn out to be not a big deal. Sure, an intern will develop skills over time, but perhaps generative AI will also improve over time, so it's a wash. I think it's a very open question, exactly how good our current architecture of AI can get using current techniques. But people are working on new ideas all the time. Maybe it's irrelevant that you won't be the master of your customer's problem yourself, because the AI will be so accurate and quick at producing information that you can produce the same quality of work product. But none of these are sure things. And even if they are, think about where it leaves your business. If your work product is largely being produced by a generative AI that runs on someone else's server, what value are you adding? Are you just a salesperson for Google? Is your whole business going to be selling access to Microsoft Word? And if that's the case, how long do you think it'll be until your customers realize that and cut out the middleman? On this somber note, we'll conclude this workshop series on the generative AI. As I noted at the outset, the law and the tech in this field is rapidly changing, and I expect much of what I've talked about to be out of date within a year. Heck, some of it might be out of date by the time this goes live. Nevertheless, it's critical to be aware of the legal landscape, to navigate it, and to understand what our legislatures are grappling with. Hopefully, together, we can carefully navigate this new world. If you found this series interesting, please visit us at Underhill Law, or visit at the link below. We do in-person workshops before putting up these videos in Colorado, and we'd love to add you to our mailing list. Thanks again, and see you soon.